Okay, now we are moving on to Law of Contracts, CCRI, Spring 2020, Chapter 20. And this chapter begins our discussion of contracts under the Uniform Commercial Code. And from here through Chapter 23, the next 4 chapters, we'll be pretty much discussing the reality of things under the Uniform Commercial Code and how that differs from common law contracts. The Uniform Commercial Code was drafted by a commission of law professors, judges, and practicing attorneys in the 1940s and 50s in an attempt to simplify the existing situation where 50 states had 50 different sets of commercial law, contract rules, contract laws, and regulations. And as the country was becoming more and more of a continental-wide country for goods and services, the having to deal with multiple state laws and getting goods from one place of manufacture shipped across several states to a destination state had just become unworkable and unwieldy and outrageously expensive for manufacturers and merchants. So the Uniform Commercial Code was an attempt to set up one comprehensive set of rules for all commercial transactions, and particularly to cover the sale of goods. And later it was amended to add a section called dealing with leasing of goods. So, under the UCC, contracts for the lease and or sales of goods are controlled by these laws. They control the form and means of payment. They control the rules of shipping and delivery. They deal with security interests where one party is using the property or the goods as collateral to ensure the completion of a contract or payment on a loan. So they are very important, and they involve all kinds of dealings between manufacturers and merchants, merchant to merchant, and between merchants and consumers. Basically, they cover the sale of goods. A good is a piece of tangible personal property that is can be transferred from one party to another. A lease is a situation where the ownership of the tangible piece of personal property is not transferred, but is retained by the lessor, by the original owner, but it is given for an extended period of time upon a contract to someone else to utilize and to use. Goods under leases would have the same definition as goods under contracts for sale, and again, it's a tangible personal property. Clothing, cars, furniture, those types of items are what is covered. Even foodstuffs, futures, cattle, minerals, anything that has tangible reality. It does not, the UCC does not cover real estate transactions, intangible assets such as stocks and bonds and copyrights and trademarks. It does not cover services. Right? Now, some situations get confusing. As with everything in human life, we can make things very complicated, so sometimes it is difficult to determine exactly what is going on in a contract, in a situation. There are many situations where something begins its existence as a piece of tangible personal property. That is, it is an item, a good, it's not attached to real estate. However, along the way, it is attached to a piece of real estate, such as a lighting fixture or a dishwasher installed into a residential property. Once something is permanently attached to real estate, it becomes real estate. The technical term for that in real estate law is we call it a fixture. So it was something that began its life as a piece of tangible personal property, but by virtue of being attached to a piece of real estate, it now becomes part of that real estate. Once an item becomes a fixture, it is no longer covered by the UCC, but it would be covered by the particular real estate law of that state or that jurisdiction. Another situation that gets complicated is where both goods and services are involved. You go to a salon to have your hair done, and as part of the service, they provide conditioner and hair dye and shampoo, and also you may, while you're there, buy some of their products to bring home and to utilize. What is the nature of that transaction? It combines both goods and services, and certainly the services are not covered under the UCC. The courts tend to take a view of looking at what's called the predominant factor. And they even call it the predominant factor test. So if you're going into the salon to have your hair done, and ancillary to that, you end up having to pay for a bottle of shampoo and a bottle of conditioner that's used on your hair, that the primary purpose of that was to receive the service. So that would probably not be considered a Uniform Commercial Code contract. However, if you were to buy $150 worth of product to take home with you for your own personal use, that part of the transaction would absolutely be covered by the Uniform Commercial Code and would apply and would not be considered a service contract. Many common law rules still apply, even though the UCC has supplanted some of them. So how a contract is made, offer and acceptance, and various other parts of common law reality have been just either adopted into the UCC, or the UCC kind of operates on top of them. Now, where the UCC has a specific rule about some aspect of law, and there was a different common law rule, the UCC, by virtue of being a statute and by virtue of being later in time usually, takes precedence. So if you reach a situation where you have a conflict and there appears to be a common law decision that says you do this, but the Uniform Commercial Code says you do that, again, if it is a transaction dealing with goods or with the leasing of goods, then the UCC rule would take precedent and the common law rule would have to give way. The UCC makes distinctions between consumer transactions and transactions between merchants. All right. It covers both situations in most dealings of goods, but however, it does give certain different rules when merchants are dealing with merchants as opposed to when a merchant is selling to a ultimate end-use consumer. A merchant, under the code, is defined as someone who deals in the goods as a business. They hold themselves out to have knowledge and or skill relating to the goods being sold, and it could also be a person who hires a merchant to deal for them in business transactions. There are certain situations where people may own a business and they hire other people who are experts in the product of the business to deal with things. They would still be held to be merchants. Right? Leases of personal property, from things as large as automobiles down to small $100 phones and copy machines and printing machines and offices, have become a large part of the present reality. So again, the UCC 2A applies to these situations. And again, as I said a little bit earlier, ownership here or title to the goods remains with the lessor. However, for a period of time, for a fee, the goods are given into the possession of a lessee. Now, a lessor who regularly engages in the business of leasing property would be considered a merchant, whereas someone who does not regularly engage in property and the goods are primarily for financial, family, or household use and the total lease is under $25,000, that person could end up leasing property but not be considered a merchant. Leases sometimes are just for the use of property, but very often they are a way to finance the property, so that instead of just borrowing money from the bank to buy this piece of equipment, or not, instead of paying for it over time after I've already purchased it, the owner leases it to me and the lease payments are made for a period of time, and at the last lease payment the property then becomes the property of the lessee. They come to own it. So it is, in many cases, particularly in business cases, the leases are leases to own and they are substitutes for getting financing through other means. The way that sales and lease contracts are formed under the UCC is similar to the way they are formed under the common law. There are rules that the UCC applies, but the UCC is even more free than the common law in couching everything unless the parties agree otherwise, meaning that the parties are very free to decide what they want in their agreement, how they want things to be handled, how they want to be paid, what's going to happen, and the UCC really sets up rules just in case the parties forgot to cover something. The UCC will have a rule to apply to say that, well, since you didn't think ahead to cover this particular aspect of your transaction, here's what's going to happen. Very much like the common law. It does the same thing in a lot of aspects, but the idea here is to make the parties as free as possible to negotiate what they want, and then for the courts to have their main job as determining what was the actual intent and will of the parties, and that is what we're going to enforce. Now, under the UCC, offers need not be as definitive as that common law. There can be open terms that could be filled in by the court, as long as the party determines that there was some intent to make a contract and there is enough evidence to find out a basic idea of what the intent was, and for the court to be able to formulate some kind of remedy for the party who claims that they were breached or they were aggrieved. The court will fill in many of the missing terms in a UCC offer or in a UCC contract. One of the things that it will not fill in, however, is quantity. And that is particularly when we're dealing merchant to merchant and we're ordering large numbers of goods. The only party who knows what their needs are and how much they wanted would be the buyer of the goods. And just as under common law, the courts were loath to insert the price, the UCC does not have as much issue with price, because there are situations where even if the price was left out, they will look to outside indexes or to what's going on in the market with these goods to find a reasonable price. But the one thing they cannot determine is how many did the buyer actually want. So if there is no quantity listed in an agreement or listed in an offer, then it may fall. An open price term, as I just said, the price can be determined as a reasonable price at the time of delivery. It must be looked at in good faith, which the UCC generally applies to all situations, all transactions, and all part of transactions, is that the parties must act in good faith, and the code defines good faith as honesty in fact, so that you're not trying to defraud or get something over on the other party, and it must be commercially reasonable. And because we're dealing in most situations under the code with products that are sold by a wide number of people around the planet in a number of situations, the courts are very free, and the code gives them the permission to look at what is going on in the marketplace, what are other merchants, buyers, and sellers doing to fill in missing terms in a contract between parties. Delivery terms can be open. If no terms are specified, delivery takes place at the seller's place of business. So in effect, if you call up someone and say, I want to order 5 cartons of product X, and they say, fine, that'll be $50 per carton, so that'll be $250. And you say, oh, good, when will they be ready? And they say the day after tomorrow. If there is nothing more, under the UCC, you have an agreement at that point. You have a contract, and because you did not speak about shipping, that delivery takes place at the seller's place of business. The presumption under the law is that you, as the buyer, since you didn't arrange for any other transportation or anything else to happen to the goods, you are going to arrive or have somebody arrive at the seller's place of business to pick up these goods. Payment can be in any reasonable commercial form. So it could be cash, it could be by check, it could be by money order, it could be 30 days after delivery. Depending on what type of good, depending on the industry you're involved in, any of these could be reasonable. The court does say that if somebody demands cash payment, particularly if that had not been demanded up front and had not been written into the agreement, that the buyer has an additional day to perform to obtain the cash. That if they are surprised when they show up to gather the goods, to be told that their check is not good, that they must, or their credit card is not good, they must pay cash. They must be given a reasonable time to go out and get that cash. In terms of delivery, if the product is to be delivered, the time is a reasonable time if no time has been stated otherwise. If delivery is part of the agreement, but they haven't discussed terms or what carrier, then it is left under the UCC for the seller to decide how delivery is to be made. Seller may choose the method. If the parties have been involved in an ongoing product, I know at my office we have regular agreements with Staples and Home Depot and WB Mason to have certain things delivered to us on a periodic basis, such as cleaning supplies, paper towels, toilet paper, pens, pads, pencils. Once we have set that up with an initial order and then stating we want a repeat order every month or every 2 weeks or every 6 weeks, whatever it is, that basically the original agreement would continue to apply under the UCC and would determine the rules for what's happening. There could be variations in prices where the seller may from time to time inform us the price of X has gone up. But basically those things would remain in place and would continue to occur until either party decided that they were done. And because there had been no set date or set time for the agreement to end, either party has a right at will to say, all right, I'm done, this was enough, thank you, but no more, and to terminate the agreement. Now, certainly, if you had signed an agreement that you are to supply 12 reams of copy paper every month for 12 months, in that type of situation, neither party could back out. They have set a definite date of duration of the contract. By extrapolating the date over the amount, you can determine exactly how much is supposed to be delivered over time. So that contract would have to play out for the full 12 months, and if either side attempted to terminate it, they would be breaching. But when there is no set termination date, then the agreement basically becomes, under the UCC, an at-will agreement that either party can change at either time. If the contract does not specify assortment, then the buyer may choose. So if it's a type of item where it comes in a variation of colors or other type things where you have choices to make with an otherwise identical product, unless it is clearly stated in the original agreement how much of each color shirt is to be delivered, the buyer would ultimately have the right to choose, not the seller. Now, there are something called requirement contracts. A requirement contract is a contract that says, I will buy everything that I need from you. The opposite of that is something called an output contract, which is a contract where the buyer says to the seller, I'll buy everything you can produce. In both these situations, the actual amount is not determined. So quantity is not determined. They would otherwise fail under the UCC, except that the code imposes a reasonableness term here on what the amount is. And basically, what they normally do in these cases, they will look back at what was reasonably bought or what was reasonably produced in the years or months before the contract, because the idea being that entering into the contract, the parties must have known what one side could produce or what one side could use, and that's what they had in mind when they entered into this agreement without stating an actual number of goods to be purchased. Merchants under the UCC can make something called a firm offer. Now, under the common law, there really was no such thing as a firm offer. An offeror could make their offer, and it could be revoked at any time before it was accepted by the offeree. Under the UCC, and the only exception to this at common law was an option agreement where one party paid money to keep the offer open for a period of time or until certain conditions were met. So, but unless you had an option, and options are funny things. We talked about them a little bit under common law, but really, I almost look at them as contracts to enter into a contract. In my mind, the option itself is an agreement, a contract, so we're beyond an offer stage. But in a pure offer under the common law, the maker of the offer could always revoke it prior to us being accepted. Under the UCC, it allows merchants to make something called a firm offer. And once the merchant makes a firm offer, then offer stays in place until it expires, either by a reasonable time if none is set, or at a time stated in the offer. So between merchants, if I am selling digital phones to a phone store, and I say I have 50 of X model available, and I will keep this offer open until May 1st, 2020. Under the UCC, I am bound by that as a selling merchant, and at any point up to that drop-dead date, the person who received the offeree, could come in and could accept. Now, under this rule, to keep it from becoming chaotic and confusing and fraudulent, if I make a firm offer, that has to be made in some type of writing or electronically preserved communication, and the offeree would have to accept the same way. So we do have some evidence of the existence of this firm offer and the reality as to whether it was or was not accepted within the set time or a reasonable time. Under the UCC, all the different things such as the mailbox rule, the mirror image rule for acceptances are done away with, and the UCC basically says that any commercially reasonable form of acceptance will create a valid acceptance to the offer, which leaves parties free to do acceptances by emails, to do acceptances by telephonic communications, by faxes. A matter of fact, the way things have progressed in recent years, accepting by mail might actually not be commercially reasonable at this point in time, because in many businesses it would take place too slowly. It would take too much time. So again, it would vary from industry to industry, type of good to type of good, but when acceptance can be made in any way that is reasonably seen as being able to get notice of that acceptance to the offeror. Under the UCC, the mirror image rule is done away with, in the sense that the offeror can come back with additional terms and there could still be a contract. So if I send out to one of my business associates, I offer to sell you 5 boxes of X for $10 a box, and he comes back and says, yes, I'll take them so long as you can deliver within 2 weeks. Under the UCC, if I do nothing further, we would have an agreement. And it's incumbent on me to read and see what's coming back to me. And if that comes back and I can't deal with that delivery date, then I would have to, in effect, contact the offeree and say, no, I could sell it to you, but I can't deliver it by that date. We don't have an agreement. If I am silent, if I just accept that to come back and I don't challenge it or try to modify it in any way, then the court would say that we had an agreement and that a contract had been formed. Now, there are some limits on this. Number one, it's between merchants, not between merchants and consumers or consumer to consumer. The offer expressly limited, except times when this will not apply, all right, is if the offer was expressly limited to acceptance of the terms as stated. So one of the things I could do as a merchant is in my offer say, I offer to sell you 5 boxes of X for $10 a box, delivery to be made in 1 week, and no variation in terms will be accepted. By putting that language in, then in effect I am calling the mirror image rule into play, and I'm saying that the offeree must answer in reply exactly as I have stated the offer. But if I don't do that, they're free to modify the terms. The terms cannot materially alter the contract. So the terms cannot change price. They probably cannot change quantity. They certainly couldn't change place of delivery. They couldn't add any large expense or burden to the original offeror. And finally, the offeror can object to the changed terms in a reasonable time and say, no, I can't accept that. You have to go back to the original terms I offered, or I cannot do it. The courts very often, though, will look at this, and particularly if there's been a course of dealing, a course of trade usages between these two merchants in the past, even when an offeror comes back and says, gee, I don't think I can really do that. If it's something that the offeror had been doing in the past, the court might say that, no, you actually do have a contract. All right. The courts will always look at prior dealings between merchants to see what the reality of their dealings were and to kind of contrast that with what they had put in writing. And very often the reality is we lawyers write up wonderful grand forms for the merchants, tell them do this, do that, file this, file that, and then they go about, particularly if they're getting along well and they're working well together, changing that without changing the form so that the performance that's going back and forth is actually different from what is in the written requirements. Because that is such a commercial reality and the way things happen in the real world, the UCC allows the courts to look at that and to basically modify the written agreement by what the actual practice was between the parties. Now again, on a one-off type situation where I'm doing one deal with another merchant, that would not apply. But if I'm in a situation where I have been buying and selling goods to and from this person for the last 15 years, the courts absolutely have the power to look at what we did, not at what we said, to determine what our real agreement was. An offeree can return an acceptance, and they can make it conditional on accepting every new term. So just as the offeror could say, you must accept this exactly the way I presented or it's not valid, the offeree can add new provisions and say to the original offeror, accept all these provisions or we don't have an agreement. All right? If the original offeror refuses to accept that, there is no contract. If there are inconsistent terms, so that the two sides have sent forms back and forth, and in there are provisions that contradict each other, so long as they're not material to the contract, they're not about the principal things in the contract, the court can ignore the contradictory terms and can look at the other terms and say, gee, there was enough here that we believe you guys had an agreement, and yes, some of the things about, what delivery date or was payment going to be made by check or credit card, those are not significant enough to undo the agreement that you had. Part of this is called the battle of the forms. Most merchants use pre-printed, preset order and acceptance forms, usually written by their lawyers, usually written to protect their side and not the other. And again, in many situations where business people are responding, they have pre-printed and preset forms that they use to respond. And a lot of this stuff has to do with the legalities of what happens if something breaks down, how are we going to handle a breach of contract, how are we going to handle litigation. They may not be things that are primary to the contract performance itself. And again, the courts are free to strike those things and to look at the core of the agreement. What were we really attempting to perform here, and to tell the parties, no, you were close enough, you had an agreement, we can undo these other things. They were just somewhat meaningless terms that your lawyers had stuck into these forms, but they weren't the real basis of your agreement. The UCC requires consideration as a basis for a contract in the same sense that the common law does. However, subsequent changes to an agreement do not require consideration. The UCC attempts to recognize commercial reality, which is that things change, and sometimes things change quickly. And because of that, even though parties entered into a contract that they were both happy with on Monday, by Thursday, one side or the other, or sometimes both, may not be happy with the contract and they wish to amend it. So the UCC allows merchants to freely change their contracts after they've been entered into. The only thing is that in most situations, this subsequent change must be made in writing. All right. If a merchant wants a consumer to sign a form saying that no verbal changes can be made. And now that's an interesting thing. Sometimes the subsequent changes are made by implication, by how the parties actually acted, and sometimes they can be made verbally, although the preferred way is to have them done in writing, either on paper or by some kind of electronic communication that is stored. But if that does not happen, the courts can look at the words. However, and with a consumer, if a merchant wants to basically use an integrated type contract and prevent any verbal statements from affecting the contract with the consumer, the merchant has to put in a separate line to be separately initialed or signed by the consumer, saying that the consumer realizes that anything told to us verbally will not apply, that only the written words on this piece of paper are the true agreement. the Uniform Commercial Code for sales does have a statute of frauds, and it basically says that any sale of goods over $500 in one transaction must be in writing, and any lease of goods where the total lease payments will come to $1,000 or more must be in writing. The writing, just like under the common law of statute of frauds, the writing must indicate there is an intent to form a contract. There must be a signature by at least one party, the party being sued at this point, and the quantity needs to be stated in the writing. All right. Between merchants, one can send a writing, the other can respond verbally, the other can respond by email, as long as we can show that an agreement was made and there was some record of the transaction going back and forth, the statute of frauds will be satisfied. Now, just like a common law, the UCC version of the statute of frauds has exceptions. So, if we're dealing with specially manufactured goods, where I ask a manufacturer to create something unique for me, and that those goods are not suitable for resale to another buyer for another use, as soon as the manufacturer has taken substantial steps to create the goods, we no longer need a writing. The mere fact that somebody will go out of their way to set up production of something unique is deemed to be sufficient to show that there was some kind of an agreement that I had requested this item to be made for me. If there's an omission, so if one party admits, and this happens in common law too, if one party admits there's an agreement, then we no longer need the statute of fraud. So this becomes very important. When you're dealing in negotiations with emails, you have to be very careful to make it clear in each email, if you're not in an agreement yet, that this is not our agreement, we are still negotiating. If you do not do that, then some of your emails could possibly be later read to deem that, well, you're admitting that you'd already reached a point of agreement, even though you didn't have it in writing yet. We have all these communications going back and forth, and as of such and such a date, they seem to indicate that you folks had agreed, and you could be bound by that. So parties, and they don't do this. I know my own commercial clients don't do this as much as I ask them, but emails have made things difficult because the UCC does not require a formal integrated signed contract on parchment paper for something to be valid. And so in the flurries of emails that we just zip back and forth every day, and God help us, I suppose that even applies to text messages at this point, you could be deemed at a later date by a court to have actually entered into a binding contract agreement. Partial performance. If payment has been made, goods have been shipped, goods have been identified, then the statute of frauds part of the UCC does not have to apply. The mere fact that people began working on performing the agreement shows that a contract or an agreement existed. The parole evidence rule. Now, at common law, parole evidence rule said that if you had a fully integrated contract, you cannot challenge it in court at a later date by using verbal testimony from verbal back and forth that happened prior to the signing of the contract. The courts, however, are allowed to make an exception to this to show a course of dealing, prior dealings between the parties that did not follow a written agreement, or trade usage, what is done in the trade or in that business on a regular basis. What do words mean to that business or to that trade? A course of performance, that in a contract where there are multiple parts to the performance, multiple deliveries, that what did you accept in prior deliveries? That can be brought in as a verbal testimony. Where there are a number of performance points along the way, prior deviation from the written agreement can be verbally brought into court to show that, oh, no, we modified the agreement, or actually we were never going by what was actually written. So the parole evidence rule still does exist to a point under the UCC, but basically the courts have been given broader powers to bring in verbal testimony. And I think more importantly, the idea you should be getting at this point is, what actually happened. Part of what's going on here is the UCC is giving the courts the freedom to say, all right, I don't care what your lawyers put down on paper. What were you folks actually doing? And we're going to hold you to the reality of what was actually going on back and forth, because in all likelihood, the fact that you were allowing this to go back and forth for a time indicates that that was your actual agreement, that that's what the contract was supposed to be. And now that one side or the other isn't happy, now we're going to pull the papers out and try and get into a war of paperwork to say that, oh, well, so-and-so didn't exactly do this under Clause 92 of the contract. If you had allowed them not to do that under Clause 92 of the contract in 20 prior deliveries, under the UCC, you're going to find the court's going to ignore that clause and say that you either waived it or it never really was a true part of the bargain for consideration. There are rules of construction. So when the court is trying to interpret an agreement under the UCC, there is a set pyramid hierarchy of things the court must look at. First and foremost, the court must look at express terms. So what did the parties say? What did the parties write down? What did they verbalize are the most important things. Secondly, they look at a course of performance. So in a multi-part contract, we're now on part 5 out of 20, and parties are claiming breach. What did you allow in the previous 4 deliveries, the previous 4 payments? With course of dealings, all right, you've entered into multiple agreements over the same type of thing with this party over the years. What did you do in the past? And then finally, trade usages. What do they do in this business? What do they do in this trade? Unconscionability is still part of the UCC. And unconscionability, again, is the idea that a contract is so unfair, so one-sided, that by enforcing it, the court would actually be doing injustice, not justice. If the court finds that a contract or a specific term in a contract is unconscionable, then under the UCC, the court is free to refuse to enforce the contract, to refuse just to enforce the unconscionable part of the contract, or to basically reform the contract and limit the terms that are unconscionable so that an unconscionable result is not going to occur, that it is avoided. So again, the concept exists under the UCC, but the courts are given a little bit more freedom to deal with it than they had under common law and under regular contracts. There is a good chart on page 373 of your book that lays out some of the major differences between common law contracts and UCC contracts. Now, Chapter 20 does go into dealing with international sales of goods. We are not going to cover that here. And I would venture to say that 2 things have been occurring. Number one, the Trump administration has taken great strides to end what have been 40 years of increasingly more and more relaxed rules dealing with international trade and international contracts. And as part of their intention to impose tariffs and to try and bring industries back to this country, that whole loosening and making things easier and less difficult appears to have come to an end. And I would venture to say, after what has happened between China and this virus and the breakdown of trade between the United States and China, there's going to be a major rewriting of international sales agreements and contracts over the next several years. So hold on to your seats and your hats, because that could get very interesting for anybody who's trying to be involved in that type of thing in the near future. Last 2 things in Chapter 20. If you have an option to cancel clause in your agreement, and this applies both at common law, remember, I think we talked about this at common law. If you have an option to cancel a contract in clause in your contract, says, well, I agree to buy 50 items of this per month from you at $100 per item, but I have the option to cancel it at any time. At common law, many judges would have argued that that was not an agreement, because one party has the absolute right to to cancel at any time. Under the UCC, they take the position that as long as that agreement was entered into in good faith, and as long as the parties arranged for one delivery, then there is a valid contract, and that one first delivery will constitute sufficient consideration to uphold the rest of the contract, even if the buyer cancels it, if either side cancels it in the second month. So, those types of contracts are allowed, they are permissible, they can be enforced. And the same thing, again, with requirement and output contracts that we talked about a little bit higher earlier in this lecture. I can contract to buy everything that I require from you without setting a definitive amount. I can also contract to buy everything that you can produce of a certain good without setting an amount. We are both bound by good faith, and because of that good faith requirement, the courts have held that these are not illusory agreements, that there really is consideration, and that neither side can either ramp up or cut back on their needs or their productivity to try and basically force the other side into something unreasonable. Okay, that terminates chapter 20.